This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
For today's talk, as we've been preparing for this project, it's become clear to me that the evidence rules in the United States are designed for a different kind of trial process than the trial process in China. So to understand both systems, I think we have to start with what is the starting point for the evidence rules and how do they work with different trial systems. So for purposes of today's discussion, when we talk about the rules of evidence, we're mostly going to refer to the federal rules of evidence. But I want to acknowledge that the federal rules of evidence apply in federal court in the US, and they tend to serve as a model for many states, but there are some variations from state to state. Our evidence rules also have to incorporate some constitutional and statutory provisions. So, but we're mostly going to be talking about the federal rules of evidence. As a companion to the federal rules of evidence for the People's Republic of China, for evidence law, we're looking at the criminal procedure law and various judicial interpretations and regulations. Interestingly, both in the federal rules of evidence and the Chinese criminal procedure law, the statements about the purposes of the rules are quite similar. In the federal rules of evidence, it's very explicit in Rule 102 that the purpose of the rules is to ascertain the truth and secure a just determination. And similarly, in the Chinese criminal procedure law, one of the purposes is to have an accurate clarification of the facts in criminal cases. When we think about US trials, it's important to remember some of the key aspects about the trial. And I think one of the ways of describing it is that a trial in the United States is a very dynamic process. All of the evidence only counts as evidence when it's introduced in court and accepted as admissible by the judge. So all of the evidence, almost all the evidence, is presented through witness testimony. As you know, in criminal cases, often the trier of fact is a jury, which is 12 ordinary citizens with no special legal training. And they're hearing the evidence for the very first time at the trial. So it's a very dynamic process. And the presentation of evidence is adversarial. Each side presents the information that they think is most helpful to their case, and they challenge the information or the evidence that is most unhelpful to their case. There's a certain unpredictability to the evidence, because even though an investigation has occurred and the lawyers have prepared, when witnesses testify in court, they sometimes give more details than they've given before. Sometimes they're asked questions that they haven't been asked before. Sometimes their testimony changes. And so the rules of evidence have to deal with the fact that the evidence comes in a dynamic fashion. In contrast, in general, the Chinese system is a little bit more like the continental legal system in that the police investigators put together a dossier of all of the evidence that would include all the witness statements and other evidence, and all of that goes into a file, gets presented to the prosecutor. Prosecutor might supplement it, and then the prosecutor presents that evidence at trial to the court. So by the time the case comes to trial in China, the evidence is pretty much solidified and is relatively predictable. The witness statements are not going to change. They're written statements. The defense may agree to some of the evidence or may disagree or make some argument about it, but the evidence itself is not going to change. There are very few witnesses who testify in person. And in contrast to the jury system, the judge or a panel of judges will decide what facts have been proven. Those two trial systems, lead to different starting points in thinking about evidence. And in China, as you think about reforming your trial system and having more witnesses testify, you might have to adjust some of your evidence rules to think about evidence a little bit differently. We're going to use a hypothetical case to illustrate some of the points that we want to make in the rest of the presentation. And in this slide, I've just given you some very simple facts about the hypothetical bank robbery case, case where a white man walks into a bank with a gun and demands cash from the bank teller, and the teller gives him $15,000 in cash, which he stuffs in a backpack, and then he runs away from the bank. There's an eyewitness named John Smith who sees the bank robber run away, and he notices he's wearing a white hat. And the hat falls off the head of the bank robber as he's running away, and the hat is recovered at the scene. So we're going to continuously ask questions about what evidence would be admissible in court. We're not talking about all of the evidence in the case. We're just picking out a couple of items of evidence. So one would be the eyewitness, John Smith's in-court identification of the defendant. Is that admissible? The second is the eyewitness, John Smith's identification of the bank robber's hat. How do we introduce that into evidence? The third is the hat itself. The hat was recovered at the scene. How do we introduce that into evidence? And I'm just going to add a fact that we're not going to talk about much, but later on in the trial, there will be a witness who will testify that DNA found on the hat matched the DNA of the defendant. And then the fourth item is a post-arrest statement by the defendant. In this case, the defendant did not confess. In fact, he denied that he was involved in the bank robbery, but he admitted that he owned a very similar hat, but he claimed that he lost it before the robbery occurred. So as we talk about the concepts of evidence, relevance, testifying based on personal knowledge, authentication, we're going to come back to this hypothetical and these examples.